Okay, Robby, what's on your radar today?
All right, well, while we continue, obviously, to talk quite a bit about the fallout from the Dobbs decision and the end of Roe v. Wade, I wanted to call additional attention to another Supreme Court case that we just briefly touched on yesterday at the end of the show as the decision was released. Now, that case is Kennedy versus Bremerton School District, and it concerned prayer in public schools. The case involved a man named Joseph Kennedy, who, by the way, is not closely related to the former Supreme Court Justice, former Senator, former Attorney General, or former President, just a popular name, who worked as a coach at a school in Washington State. Now, Kennedy is a Christian who was in the habit of praying on the 50-yard line during and after football games. He didn't make anyone else pray with him, though teammates were welcome to do so. Eventually, the school fired him, worried that his religious displays were violating the Establishment Clause of the First Amendment, which prohibits public institutions from seeming to endorse a particular religion and force it on the people. But in a 6-3 decision, the court's conservative majority, Roberts, Thomas, Alito, Kavanaugh, Gorsuch, and Barrett, held that Kennedy had not done anything wrong. He was free to practice his religion, so long as he wasn't coercing anyone else into going along with it. Quote, respect for religious expressions is indispensable to life in a free and diverse republic, wrote Gorsuch in the majority opinion. Here, a government entity sought to punish an individual for engaging in a personal religious observance based on a mistaken view that it has a duty to suppress religious observances even as it allows comparable secular speech. The Constitution neither mandates nor tolerates that kind of discrimination. Mr. Kennedy is entitled to summary judgment on his religious exercise and free speech claims. Justice Alito concurred with Justice Gorsuch, writing, quote, the expression at issue in this case is unlike that in any of our prior cases involving the free speech rights of public employees. Petitioner's expression occurred while at work, but during a time when a brief lull in his duties apparently gave him a few free moments to engage in private activities. When he engaged in this expression, he acted in a purely private capacity. The court does not decide what standard applies to such expression under the Free Speech Clause, but holds only that retaliation for this expression cannot be justified based on any of the standards discussed. On that understanding, I join the opinion in full. Justice Sotomayor dissented, writing this. Properly understood, this case is not about the limits on an individual's ability to engage in private prayer at work. This case is about whether a school district is required to allow one of its employees to incorporate a public communicative display of the employee's personal religious beliefs into a school event where that display is recognizable as dissenting, part of a long-standing practice of the employee ministering religion to students as the public watched. A school district is not required to permit such conduct. In fact, the Establishment Clause prohibits it from doing so. So the disagreement between the justices then is about a couple things. The extent to which Kennedy's decision to pray was disruptive. Also, the liberal justices tend to take the view where any religious display is akin to establishing religion, which violates the First Amendment. Conservatives don't treat religious speech fundamentally differently from non-religious speech. Indeed, to do so, in their view, would be showing a special hostility to religious speech, which is a kind of viewpoint violation that, in their view, is not permitted by the First Amendment. Now, reasonable people can obviously disagree on this ruling. All of our SCOTUS justices are, in fact, very smart individuals with very compelling arguments for why their view of the law is correct. But I mainly wanted to highlight this because I was actually struck by the reaction to the decision on social media, where I saw countless liberal Democratic commentators completely misunderstanding what would be the conservative arguments in this case. First, there was David Frum, a writer for The Atlantic. Frum said that SCOTUS cleared the way to chants of Allahu Akbar before sporting events. My reaction was, so what? Fine, go ahead. That's free speech. Muslim coaches and athletes deserve it as well. Frum was hardly alone, though. The phrase Muslim or Jewish was trending on Twitter yesterday because so many people were asking, well, what if the coach had engaged in non-Christian prayer? What would you think then? Checkmate, conservative. But we know the answer to this because the court just settled it. Religious belief would be protected. That's what the decision is about, and that's what conservatives want. They will gladly allow more establishment of Islam and Judaism. That is what the point is, allowance for religious observance. And yet it was this kind of thing, over and over and over again. Do Democrats just not understand the first thing about conservatives anymore? Like, we're not in the immediate post-9/11 aftermath where, you're right, there was a lot of anti-Muslim kind of bigotry and just kind of all circles, but also in conservative circles. That's over. Time and time again, I see Democrats proposing purported gotcha scenarios, ostensibly to trick Republicans, when the thing they are proposing are things Republicans support. If you followed social media over the past few days, you probably saw lots of sentiments from Democrats relating to the abortion decision that were along the lines of, well, if we're going to criminalize abortion, are we going to criminalize men not providing financially for the babies these women are being forced to have? But many Republicans and virtually all social conservatives would be fine doing just that. So there's a popular meme going around that captures this tendency really well. It's the "your terms are acceptable" meme. The standard issue liberal thinks he can trick the conservative by saying, well, if we're banning X, why don't we also ban Y? But the liberal doesn't realize that many conservatives want to ban X and Y. There's a real information asymmetry to the two ideological camps right now. It often seems to me, and let me say, by the way, I'm somewhat at least impartial here, given that I agree with both sides on some things and disagree on others, that conservatives seem to me to understand liberal beliefs fairly well, while Democrats don't know the first thing about what the modern right believes. They're still kind of stuck in what the right believed 15 years ago, as we were kind of discussing in our opening discussion. So I know you disagree on this court case, and look, I understand the other argument for it. The more research I was doing, it's clear I think he was straddling the line between too much religious display and in that, they were having the team kind of all on the 50-yard line. He was saying no one was coerced into doing it. Sotomayor was then kind of arguing that, well, but what if they feel left out because everybody's doing it?
A student, in fact, said that they felt coerced into doing it. One of the players in the team, the reason this became an issue is because they disclosed to their parents or another school official, I forget which, that they felt as though if they didn't go to the center of the field and kneel and pray with the coach after games, as had become a tradition,
that it would be socially ostracized.
No, that he wouldn't get as much playing time. He felt like his career on the football team was hanging in the balance based on whether or not he was perceived as supportive of the coach's own religious beliefs. Now, certainly you can see how that would be frustrating. So I will agree with you. I think that some of the responses to this have the effect of frankly being denigrating to these other religions. When you say, what about Allahu Akbar? You're not only misunderstanding where I think conservatives are right now,
right.
You are kind of catering to the most uncharitable view of how people look at other religions and presuming the worst about how they're perceived in the public light in a way that I think is kind of denigrating. So
right.
I didn't love those responses either. At the same time, it seems quite clear to me, and it's clear from previous Supreme Court precedent, that private prayer has always been allowed. I think the precedent was Lee. School public officials, whatever their religious background, whatever their beliefs are, have always been able to pray privately. That's not what this was. And I think what a lot of liberals were most frustrated about, and the key thrust of disagreement with this case that I saw, was that the majority had really misrepresented the facts of the case and really characterized the coach as having engaged in private prayer that was then being sanctioned by the state. Au contraire. He was literally going to the middle of the football field at the 50-yard line after games. That's the 50-yard line, right? That's the middle. And kneeling, sorry.
We're not the sports experts in the room, yes. The 50-yard line is the middle, yes. That I can confidently assert.
Sorry, I played basketball.
Yeah.
And kneeling with students. And if you, at this point, have students saying that they feel like that's coercive, and even more so, that it's going to jeopardize their standing on the football team. Imagine if a teacher engaged in prayer at the beginning of the classroom. Sure, you can tell your kid, oh, you don't have to do that. We believe something different in our household. But a young, impressionable mind, you can easily see how they might start to feel like, I want Miss Smith to like me. I want Mr. Smith to like me. I want to ingratiate myself to them. The rest of the class is standing and doing something. Especially when we live in a country with such an enormous religious majority. I do think it's important to take seriously how coercive it can feel to people who aren't already a part of that majority.
I think based on my reading of the Alito concurrence, I don't think the prayer in before class begins would be allowed, because I think he would say that was actually on the job, whereas after the game.
Private prayer has always been allowed in schools. That's
right.
that's not the issue. And there have been cases about whether or not saying the
teacher
pledge
does it versus the student, I think is a little different too.
My understanding is that the line is whether or not it's private or public.
Mm-hmm.
So again, I think everyone wants to respect religious beliefs, but you talk about the First Amendment. The Establishment Clause is part of the First Amendment, and the reason we're treating religious speech differently is because the Constitution says religious speech should be treated differently than other kinds of speech, especially because of the danger of establishing one religion over all others. People fled to America and founded murdered the Native Americans and then founded this country because they were fleeing religious persecution of exactly this kind in England. And Protestants felt like, Catholic, people wanted to feel as though they could practice whatever they were going to practice without feeling like the state had preference over one or the other. I think that's a really core bedrock American ideal. I think it's a wonderful thing about this country. And it's very confusing to me that I think conservatives who used to want to stand up for those kinds of rights and who wanted to look to the founding fathers, many of whom were atheist or agnostic, and really were fearful of the negative influence potentially of the church, the Pope, and the role that it played in Europe, were very clear to put as a number one First Amendment,
right.
Do not do this. Do not repeat this
Some of that was
mistake.
anti-Catholic bigotry. I don't want to bring that.
Sure. I mean, I saw someone joking.
Plot.
Someone joking on the internet that if you asked the founding fathers what they would think about these decisions, they would say, "Oh, there's 6 Catholics on the court." So we don't want that either, obviously.
Yeah.
But the fact of the matter is, you don't have to worry so much about anti-Catholic bigotry or anti-anybody bigotry if you are consistently
They'd also
neutral.
said, "Where's the authority?" We didn't have put any authority in the Constitution for there to be a federal Department of Education. They would also say
we
that.
also don't have any authority in the Constitution about the proliferation of bullets. Bullets hadn't been invented at the time of the Constitution, which is why I would argue originalism is bunk. And we are thinking, feeling people with a lot of information in our brains that didn't exist 200 years ago, and we should plot our own.
The argument on the right, the difference between conservative and liberal view on this is the state cannot establish an official religion or seem to favor one religion over another.
Or fund religion, but it's a taxes issue.
Right.
It's that he's a public employee.
Well, right, but
on the job.
But public employees have other speech rights, other rights to engage in free speech in general. And what the conservative view would be that as they're doing that, religion being one of those views they can have, speeches they advocate is not. We do not think, conservatives don't think that should be treated differently. The religion part is just about stopping the government from requiring a certain kind of religion. And just like a public employee would be free to hold any number of political views or make any certain kinds of public expression. And then, I mean, it gets tricky in schools. There's all sorts of confusing.
Should the coach kneel in the middle of the court and say, vote Democrat?
Well,
we're a Democratic football team. Come kneel with me and talk about how much the Republicans suck. You would be concerned about that sort of a thing as well. I mean, you cannot ignore the fact that this is
probably they'd be allowed to do that, right?
In private.
Yeah. Well, probably on the 50-yard line based on this decision.
No, I don't think that this is a hard case, and it's frustrating that it came out the way it did because there was precedent that already allowed him to do what he claims he wanted to do. The question is whether or not, how far down this road and how many people are going to actually have to wake up and realize that their religious beliefs are being threatened before they realize we've given.
I disagreed.
The government too much
heartily
with
here. There have been a lot of cases that have limited K through 12 students' free speech rights. The Bong Hits for Jesus case. You remember that?
No.
That one. It's literally called the Bong Hits for Jesus case. Some student had that sign up. It's just like a nonsense sign at I think it was some kind of athletic event, and the sign said "Bong Hits for Jesus," and the student was disciplined or told they couldn't do that, and went to the Supreme Court, and the kid lost. This was like a famous free speech case from I think the aughts,
So the kid's argument was that it was a religious sign, and that
it was just First Amendment protected speech, and the court said, well, it was like advocacy of illegal drug activity. Because it said "Bong Hits for Jesus," and I thought it was. So I don't want to restrict kids the actual students' free speech rights at all. Unfortunately, there has been way too much.
That does seem like a different case because it's not a government establishment. It's not an establishment clause case if we're not talking about
But it should be
federal tax dollars going to this. Yeah. But anyway,
interesting stuff.
Interesting stuff, and we'll have more for you after this.